Section 14, Rejecting Prospective Residents. Today's Fair Housing Rules and Regulations, 2026 Standard. Introduction: When no becomes a legal risk. Up to this point, you've learned how discrimination happens, how to respond in real time, how ADA impacts accessibility, and how to apply fair housing laws in your daily business. Now we step into one of the most dangerous areas in real estate, rejecting prospective residents. Because here's the reality in 2026, saying no is not illegal, but how and why you say no can be. This section ties directly back to Section 3, Modern Discrimination, and Section 7, Fair Housing Practice. Many violations today do not come from obvious discrimination. They come from policies that appear neutral but create unequal outcomes. And one of the biggest examples of that? Criminal background screening. The big issue: criminal history and housing decisions. Let's start with a real-world situation. A landlord reviews an application and sees a criminal record. Their immediate reaction: we don't rent to anyone with a record. Seems straightforward, but this is where fair housing law steps in. Individuals with criminal records are not a protected class under the Fair Housing Act. However, policies that exclude them can still violate the law due to something called disparate impact. What is disparate impact? Disparate impact occurs when a policy applies to everyone equally on its face, but disproportionately affects a protected class. In this case, statistical data shows that certain minority groups are disproportionately impacted by criminal history policies. That means a blanket policy could unintentionally discriminate based on race or national origin. 2026 Insight. You don't have to intend to discriminate to violate fair housing laws. HUD guidance: what you must do instead. HUD has made it very clear. Housing providers must move away from blanket denials and toward thoughtful, individualized decision-making. Instead of saying, no one with a record allowed, you must evaluate the nature of the crime, the severity, how long ago it occurred, whether it actually poses a risk to safety or property. Real-world example applicant. A. Minor offense. 15 years ago, likely not a valid reason to deny. Applicant B. Recent violent conviction, may justify denial. The key is that your decision must be justified, consistent, and based on real risk, not assumptions. Arrests versus convictions, a critical distinction. Here's one of the most common mistakes agents and landlords make: rejecting someone based on an arrest. HUD guidance clearly states, an arrest alone is not proof of criminal conduct and should not be used as the basis for denial. 2026 Compliance Rule. Arrests, not enough convictions, must be evaluated carefully. The three-step legal test: disparate impact analysis. When a policy is challenged, courts and HUD use a three-step process. Does the policy have a discriminatory effect? Is the policy necessary for a legitimate, non-discriminatory interest, like safety? Is there a less discriminatory alternative? If you fail this test, you may be in violation. What a compliant policy looks like. 2026 Standard. To protect yourself and your clients, screening policies must be specific and tailored, focus on legitimate safety concerns, be applied consistently to all applicants, avoid blanket exclusions, consider time, severity, and rehabilitation, be supported by evidence. HUD strongly encourages individualized assessments which include age at the time of the offense, evidence of rehabilitation, rental history before, after the offense, circumstances surrounding the conduct, high-risk mistakes to avoid. Let's break this down into real-world mistakes agents still make. Blanket, no criminal record policies, denying based on arrests only, applying rules inconsistently, making exceptions for some but not others, using criminal history as a cover for discrimination. Each of these can lead to liability. One exception: drug manufacturing and distribution. There is one area where the law is more strict. Housing providers may deny individuals convicted of illegal manufacture, distribution of controlled substances. This is considered a legitimate safety concern. However, even here, policies must still be applied consistently. The bigger picture: fair housing versus risk management. At its core, this section is about balance. You have a responsibility to protect residents and property, but also avoid discrimination. The mistake many professionals make is choosing one over the other. In 2026, the expectation is that you can do both by creating thoughtful, legally compliant policies. Real estate professional takeaway: you may not always be the one making the final decision, but you are often the one. advising the landlord, managing the process, communicating the denial. That means you are part of the compliance chain. And if something goes wrong, you may be part of the liability. Bringing it all together, the right way to say no. Rejecting an applicant is not illegal, but in 2026, it must be done. Carefully, consistently, with documentation, with a legitimate reason. Because the difference between a legal denial and a fair housing violation is not the outcome, it's the process. Online discussion. Question 1. Why can criminal history policies create fair housing violations? Answer. Because they may have a disproportionate impact on protected classes, leading to discrimination under the doctrine of disparate impact. Question 2. What is the difference between an arrest and a conviction in housing decisions? Answer. Arrests alone cannot be used to deny housing, while convictions must be evaluated based on severity, time, and risk. Question 3. What is one key element of a compliance screening policy? Answer. It must be tailored and based on legitimate, non-discriminatory interests such as safety.